Hello everyone, this is Urvashi Chauhan and you are watching Courts Today by LiveLaw. We bring to you the latest and in-depth legal coverage. Here is a brief of what all happened in the Indian courts today. I'll begin with an important information shared by the Union Government with the Supreme Court today. The bench of CJI D.Y. Chandrachud and Justice J.B. Pardiwala was hearing a petition with regard to a challenge to Section 64 of Criminal Procedure Code. Section 64 says that a woman member of the family is incapable of accepting court summons. So the question is, how can our legal system discriminate, saying that a woman cannot accept the court summons and only a male member can? During the hearing, the Attorney General for India, R. Venkataramani, informed the court that Union Government is in the process of amending the IPC, Criminal Procedure Code and the Indian Evidence Act. As you know, in March 2020, the central government had constituted a Criminal Law Reforms Committee to make suggestions to revise the IPC, CRPC and the Evidence Act of 1872. This committee, after taking suggestions from the public, submitted a report to the government in February 2022. Though the Home Minister Amit Shah in October last year had said that the government was going to come with the new drafts in a short time, the government, however, did not move any bill in this regard in the subsequent winter session or in the recent budget session of the Parliament. The Supreme Court Judge Justice B.R. Gavai made an interesting comment about Supreme Court benches and also about the conduct of advocates on record. The judge in a lighter way stated there are inconsistencies in the views of different benches of the Supreme Court. While making a self-critical note, he came down heavily on the conduct of advocates on records practicing in the Supreme Court. I should mention here that advocates on record are those lawyers in the Supreme Court who can only file matters in the Supreme Court. Not every lawyer can file cases in the Supreme Court. Only those who pass the AOR exam conducted by the Supreme Court can do so. The bench of Justice B.R. Gavai and Justice Bela Trivedi considered a contempt petition initiated against a petitioner before the Supreme Court who himself is a retired judicial officer. In the petition filed before the Supreme Court, the contemner has made derogatory remarks against the Karnataka High Court. Ordinarily, it is the responsibility of the advocate to take care of the pleadings based on a judicial discipline. The court expressed its displeasure and said that it wanted to send a message to the advocates that the standard of the bar was at the worst. The court said, and I quote, "The advocates on record file petitions. They act as a postman. Something comes from the High Court and they just file it without considering it." Another case from the Supreme Court was on the issue of gas cylinders sold in black market. The incident was of the year 1995. As per the Liquefied Petroleum Gas Regulation of Supply and Distribution Act, only an authorized officer can take action against selling of cylinders in black market. Instead of doing so in the present case, a sub-inspector initiated the proceedings and as per the act was not the authorized person. The counsel for the Punjab government argued that the accused were found in unauthorized possession of gas cylinders and on the basis of a technical issue, their conviction should not be set aside. The bench of Justice Abhay S. Okha and Justice Rajesh Bindal, setting aside the conviction, categorically stated, and I quote, "Where a power is given to do a certain thing in a certain way, the thing must be done in that way or not at all. Other methods are necessarily forbidden." The Supreme Court, in another important case, expressed its displeasure about wrong information shared by the Uttar Pradesh BJP spokesperson Prashant Umrao regarding alleged attacks on migrant workers from Bihar working in the state of Tamil Nadu. In fact, the Supreme Court said that Mr. Prashant Umrao, especially being a lawyer, should have been more responsible. The court directed him to tender an apology for spreading misinformation on social media. In another development from the Supreme Court, it has disposed of the contempt petition filed by activist Tushar Gandhi against the Delhi police for its alleged inaction in the hate speech case over the Hindu Yuva Vahini event of December 2021. The petition states that an event calling for mob violence was organized under the leadership of Sudarshan News TV editor Suresh Chauhanke in Delhi. It further stated that the Delhi police had violated the guidelines set out in Tehseen Poonwala case, as per which the police was required to file an FIR and charge sheet in this case in a timely manner. Additional Solicitor General K.M. Natraj, appearing for the Delhi police, informed the court that the investigation had been concluded in the matter and charge sheet filed. So the Supreme Court decided not to pursue the contempt case. It may be noted here that the stand taken by Delhi police initially was that the speeches made during the said event did not amount to any offence. The police had also submitted an affidavit stating the same. It was only after the Supreme Court expressed its dissatisfaction that the Delhi police registered the FIR. Another important judgment is on taxation law today. Being tax, it might be slightly technical to understand, but I will try my best to simplify it as much as I can. The issue pertains to Section 153 of the Income Tax Act 1961, and there was an amendment to this section in 2015. As per the section, when the Revenue Department is conducting a search against a particular person and finds some incriminating article against other person, they have the power to proceed. For this purpose, the section uses the word belongs to. But in 2014, there was a decision by the Delhi High Court in another case which restricted this power of the Revenue Department. It said that the word belongs to does not mean refers to or relates to. The High Court had said if photocopies of a document are seized from a person, it cannot be said that the document belongs to that person, as the originals are with somebody else. So this decision restricted the power of the Revenue Department. Now, to surpass this restriction, this Section 153C was amended by the Finance Act of 2015, which substituted the word belongs to with pertains to. The question before the Supreme Court today was whether this change by the amendment will apply retrospectively or not. The court, while allowing the batch of 115 appeals filed by the Revenue, agreed to the retrospective application of the said amendment. Thank you for watching. We try our best to bring you the complex legal issues in the simplest possible manner. If you wish to know more details about the cases I mentioned here, please visit our website at www.livelawmedia.in. Your suggestions are extremely valuable to us, so please write to us at info@livelawmedia.in. Do not forget to like, share and subscribe and support us.